A very good evening and a warm welcome to one and all. We gathered here today to witness the launch of A People's Constitution, a book exploring how the Indian Constitution of 1950 enfranchised the largest population in the world. In honor of this event, I had like to extend a warm welcome to the author and the man of the hour, Rohit. He is an associate research scholar in law at Yale University. Also, he has assisted at the Supreme Court of India with Chief Justice K.G. Balakrishnan and has worked with constitutional reform projects in Sri Lanka and Nepal. Primarily, his research focuses on South Asian legal history and comparative constitutional law, and well, the expertise of his research is evident in his book. Let's take the evening forward. And with this note, I would like to extend my heartiest welcome to our panelists, Mr. Gautam Bhatia, Nivedita Menon, Mr. Pratap, Bhanu Mehta, and Ms. Nandini Sundar. I would like you all to request them to please unveil the book. I would like to request Nivedita Menon, Professor of Politics of JNU, to come to the podium and give her insights on the topic. Thank you.
Thank you so much. I'm not sure how many insights I have exactly. But I have been following this book in the making, as many of us in this room have, listening to Rohit's presentations for a long time. And I'm not even sure at what point this idea of a people's constitution seemed to become my idea. So that is either a crime or an act of love, or both, actually quite likely both. Because at some point I found that I was reading movements like Pathalgadi, about which Nandini has written, the RTI Act, Section 377, the queer movement, that there has been an invocation of the Constitution in recent times by these movements, which claim not exactly rights, but identity, self-governance, information. And although rights are invoked, what is in fact happening is that it's a kind of a theater, performance of subversion that we see of societal and governance norms, but rooted in the idea of the Constitution. So Pathalgadi is the prime example, of course, these large green stones which have inscribed on them what sounds like the most boring bureaucratic name of an act, Panchayat Extension to Scheduled Areas Act. And it is actually the basis of a movement that is cutting across swaths of tribal land, where the demand is for self-governance, and government officials are not being allowed to enter. They've all been arrested for sedition. And what they're claiming is the basis, the legitimacy of the Constitution. The Right to Information Act, which creatively claimed that the right to freedom of expression implies full information. So this is what the RTI is based on. So you have this huge movement, the MKSS, which draws on the right to freedom of expression to say that you cannot fully express yourself unless you have full information. And what sounds like a boring bureaucratic act, but RTI warriors armed with nothing more than 10 rupee forms are apparently more dangerous to the system than Maoists, because the number of RTI activists who have been killed or injured in the process, the numbers are in the hundreds. Rohit's book, although in the making over years, arrives in that sense at a moment, for me, very opportunely, because otherwise I might have begun to think this was my idea, as I said. But reminding us of the very long history of this kind of engagement with the Constitution, treating it as an insurgent document. So now a lot of what I'm about to say will be from Rohit's book. It did not descend on the people, he says. It was produced and reproduced in everyday encounters. So what he does is he moves away from two kinds of discourses about the Constitution that we are familiar with. One is the celebratory one as a product of charismatic founding fathers. And then there's the narrative which sees the Constitution as a betrayal of the people. For example, Monto's story, Naya Kanun, which also Rohit talks about. But as those of us who have followed his work for a while, his argument is that the Constitution transformed everyday life. That there is such a thing as constitutional consciousness in people's minds, opening up ways in which the state is undone and negotiated from below, providing an option for citizens to insert themselves into an elite conversation. So all these phrases are from different parts of the book. So these citizens, Rohit also notes, are largely from groups that were socially and economically marginal in independent India. Muslim butchers, sex workers, Parsis demanding the right to brew liquor, and so on. So the Muslim butchers are demanding the right to slaughter cows, that it's affecting their livelihood. So what is significant is that citizens assert their faith that they're entitled to ways of life, professions, and so on, even in the face of the fact that such assertions often run counter to current doctrines of constitutional law. This is the point that Rohit makes, that they assert these as articles of faith, that they're entitled to this life, to this profession too, and so on, even in the face of the fact that contemporary constitutional wisdom isn't that way. The belief appears to be, he says, that the state would endorse this faith in the future. So this is an argument that does resonate with my understanding of the Indian Constitution, and perhaps many of us, but as a document very different from a classic liberal constitution, which embodied a new dispensation, which kind of closed a previous phase of history and started a new dispensation, which is your liberal constitutions of Europe. For example, there are ways in which Marxists might talk of a bourgeois constitution or a socialist constitution, and there would be elements of truth in such characterizations. However, that does not exhaust the full meaning of what constitutions are. For what we see in contemporary India is that the constitution no longer lives that singular life that liberal constitutionalism laid out for it, but has become for many sections of the population a call to radical transformation as well. So in a sense, the constitution is broken out of the confines of the liberal imagination and attempts to keep it in the safe custody of constitutional experts. I think there are two reasons for this. First, as I said, I do think that it's a mistake to read the Indian Constitution as a liberal document in any sense, because a study of the debates for example, even over the First Amendment, reflect a variety of political opinions from left to right, emerging from a mass anti-imperialist struggle. And you see it trying to balance individual and community, equality and special provisions for historically disadvantaged groups, the drive towards industrialization, rights of the peasantry. It's a very different moment in time and space from that which produced the constitutions of the West, which in a sense marked a closure of and an end to political ferment. But the Indian Constitution is seen by all participants, and not least by Dr. Ambedkar, as the beginning of a journey towards what the preamble promise. I think the second reason why the Constitution is emerging as a banner of revolt for some struggles is the nature of Indian democracy, which has rarely remained confined to participating in elections. Of course, there are many movements that do not accept the Indian Constitution as a basis of legitimation, but here we are talking about movements that do. The explosion of mass movements across the country in the past decades, and especially over the term of this regime, is an indication that democratic participation in decision-making has come to be taken for granted by the people. There is thus a growing divide between the people and the ruling elites, including political parties. What we learn from close analysis of debates over the Constitution at its founding moment is that the Indian Constitution, at least, is not a document that has managed to establish a unitary order. If it was meant and to legitimize the Brahmanical patriarchal class society that India is, it certainly failed, for it ended up reflecting the heterogeneity of impulses of the anti-imperialist movement. It ended up, therefore, being a porous document with one foot in the future. So I don't think Rohit suggests, and nor do I, that the Constitution exhausts all possibilities for radical politics, but it certainly seems to offer some kind of movements and groups the resources to think in radically transformative terms. So when Jignesh Mevani, who actually came to this event because he thought that the book sounded really interesting, he counterposes the Constitution to Manusmriti. He's drawing on the insurgent possibilities of the Constitution, a strategy that has a very long history, as Rohit's book demonstrates.
Now, I would like to call upon Mr. Pratap Bhanu Mehta, the Vice Chancellor of Ashoka University, to give us his thoughts on the topic.
Thanks. Nivedita is a hard act to follow. First of all, congratulations, Rohit. I mean, this is an absolutely brilliant book. I think it's a masterclass in a historian's craft. I think after a long time, a book at the intersection of law and history that's this riveting, this textured, even if you agree or disagree with the central thesis. I think the number of insights that jump off on every page, lots of little sort of sidelights, fascinating characters, the literary quality of the book. So, highly recommended as good summer reading, even if you don't want to read it as an academic book. Absolutely stunning book. What I'll do in the next 5 or 7 minutes is maybe just draw out 3 or 4 things that I think emerge very starkly about the Indian state from this book. The way the book is structured, and this is really just a stroke of brilliance, is in order to demonstrate the thesis, right, that the Indian Constitution is not this sort of gift from above, that it really transforms the lives of ordinary citizens. It mines an extraordinary archive around litigants. Who are they? What animates them? The kind of supporting infrastructure that is required to bring these kinds of cases that are very central to moral life in India. I mean, the 4 themes that he picks on, sort of, prostitution, beef ban, prohibition, and control of the circulation of commodities, right? Really fascinating economic history built into those themes that are still very alive in terms of, what animates us. So I'll present this succinctly and hopefully succinctly, 3 or 4 theses that I think are really quite striking, I think, in the book. I want to begin by introducing the first thesis by actually drawing your attention to the cover of the book. So most of you might not have noticed, but there are these ordinary citizens sketched, and these are actually sketched by Rohit himself. And I will do what political theorists tend to do, which is, since Hobbes' famous, front piece of the Leviathan, one can talk about the book by just looking at the sketch on the front page and say, what conception of sovereignty is embodied here? This actually cover captures a lot. And I think it captures actually more than Rohit himself is willing to say. I think the book is actually far more radical than the opening chapter makes it out to be, in the following sense. So as Nivedita very nicely laid out, Rohit's basic thesis is, it says, moving away from the Constitution as an elite construction on the one hand, or this kind of heroic moment on the other, right? But fundamentally, I think what the cases bring out is that the Indian Constitution is, in a sense, there's a constitutive tension at the heart of it that not just runs through the Constitution, but almost seems to run through most of the citizens that engage with it. And that constitutive tension can be characterized, I'll use these 2 words, rationalism on the one hand and pluralism on the other. I mean, these are kind of very familiar terms. What do I mean by that? Rationalism is, in a sense, the idea of a constitutional imagination that is premised on the thought that there's a unitary sovereignty. So like Hobbes' Leviathan, all citizens, in a sense, get represented by this unitary sovereignty. They are undifferentiated citizens in this whole. Rohit's citizens all have very differentiated identities, and these actually matter a lot to the kinds of moral claims they gave, right? So there's a heterogeneity to it, which resists, right, totalization in this sort of sovereign structure. Rationalism is the idea that in some senses there is a objective moral truth that the Constitution embodies, the kind of exercise we as moral philosophers do, what is the moral philosophy of the Constitution, right? Pluralism, by contrast, is the thought that there are actually deeply radical, incommensurable moral vocabularies that different citizens inhabit, different universes they inhabit. Even on as basic a thing like, the legality, morality of prostitution, right? And the way we often negotiate these, what radical plurality means is not just that there will be a definitive right answer to the question, should you make it legal, should you make it illegal? The way that radical incommensurability is negotiated is by actually giving people lots of different spaces, right? So you'll have groups that say, well, it's okay for us, but if you don't want to do that, that's perfectly fine. Or on the drinking case, so long as you can keep the 6 scheduled areas out, right? But there is no objective answer to the question, right? Is prohibition justified or not, right? So at heart, and what makes this constitutionalism tick is in a sense that these two competing visions of the rationalist vision of a constitution, their first principles, there's unitary sovereignty, there's a kind of homogeneity across the citizen body to which these laws can apply, deeply in contrast with a radical incommensurability, heterogeneity even of sovereign orders, who should actually control, who should take these decisions, right? And I think what Rohit's books, to me, the interesting part of the argument was not so much the elite mass distinction. I think that was a straw man of the 1950s scholarship on the Constitution. Anybody who knows law knows that merely by being enacted, it impinges on citizens' life. And when it impinges on citizens' life, it provokes resistance and strategies to deal with it all kinds of ways. Even take the case of prostitution that, Rohit discusses. Husnabai is credited to be, the first kind of articulation of the figure of the subaltern in law in their own voice, right? But as you know, Rohit, even if you go back to the Peshwa Daftar archives of the 18th century, right? It's remarkable how many of those legal cases are actually about prostitution. And actually in far more sophisticated options, right? They're talking about whether, they can inherit property to their kids, right? All of that. So there is a long prehistory that whenever law is enacted, it will shape citizens' lives and there will be modes of resistance. I think what's challenging about the book is the way it brings into focus this tension, right? Of a state embarking on a project, and in that sense, it is an elitist project, which says that because we have democratic authority behind us, we can speak for all citizens. Because we can speak for all citizens, same laws must apply to everybody. Because this is this moment of newness, a lot of these customary practices, right, must go away. So again, to take the case of sex workers, arguably the Husnabai moment seems like a pivotal moment because you had a colonial state and a democratic state trying to actually occlude the agency of these workers, right? Which was actually much better represented in customary law than it was actually in modern law, right? And often people, to defend their liberties, will sometimes reach for rationalist arguments and sometimes the domain of pluralism. This is our domain. These are heterogeneous values that can't be reconciled. And I think that is something you find both in citizen articulation, and that is something you also find in the jurisprudence. Why the Supreme Court jurisprudence is so messy, if you are being charitable to it, right? It is because it is at some level, no matter, the Constitution has a transformative aspiration, but it's a transformative aspiration in the context of a kind of radical, incommensurable understanding of the sites of governance and the values we actually bring, right? And the Constitution works or becomes a language both of the people and the elites, right? Becomes the language of radicalism, although I think we need to have a discussion on what radicalism means here, because often in India, very ordinary demands seem radical, right? Both of radicalism, but also, those who are subverting radicalism, right? Those who are using the state power to suppress it are also claiming to speak the language of constitutionalism, right? How the constitutional structure manages to encompass both of these contradictory languages, and how these contradictory languages actually cut through all of us as citizens. That's one of the really powerful stories embedded in this constitution, in this account. The second thing I'll just say, second large thesis about the state is, and this, those of us who are admirers of Nehru, have to acknowledge, and I say this as admirers of the Nehru, the post-independence state actually did really create a neurotic state. One of the interesting things about the Constitution, why citizens have to take recourse to the state, is that the state has created half the problems it is now trying to solve, right? The essential commodities regulation is just neurotic, right? What it creates is this extraordinary power of bureaucratic discretion, right? Which, by the way, it's the same logic that then applies to prohibition, right? Whatever your views on the legality or illegality of prohibition, the form of state structure that it creates, right? Or the regulation of sex work, that through the instrument of law, the creation of a political economy of bureaucratic discretion that far transcends any ideological debates. The one point of disagreement I have with Rohit is that, he describes the Nehruvian state as trying to create industrial capitalism at the context of, at the expense of usurious capitalism. And the state-market relationship is not antagonistic. I think that's too kind to the Nehruvian state. Where you do not have basic allocative freedoms, there is no market. Yes, it's almost a tautological argument that every market is a creation of a state, right? But I think to call what you describe in this essential commodities chapter as the Nehruvian project of creating industrial capital, that actually just don't buy. I think you're too polite to the Nehruvian state. What it is a creation of extraordinary bureaucratic discretion, right? Across all levels of social being. And part of the reason we invoke identities in resisting that, right, is because in part the identity claim is not just about identities versus rights. It is about this ain't your jurisdiction to regulate in the first place. So here are Marwari traders saying, look, we've been carrying on this business for years and years, right? Right? Here are sex workers saying, we have a community identity based out of, right? And part of what they want to wrest away from the state is this bureaucratic discussion. So this book raises really profound and deep questions about the state. And I think the challenging question it leaves us with, and this is the last thought I'll leave you with, which is, if Rohit's account is right, that there is a constitutional consciousness, but this constitutional consciousness can encompass these contradictory elements of both repression in the name of the Constitution and trying to use the Constitution in terms of, its emancipatory potential, then what is the specificity of this constitutional consciousness, right? It's a question I'm sure maybe Gautam will answer. He's written wonderfully about it when we invoke phrases like constitutional morality and so forth, right? The fact that these become so amenable to both modes of politics, right? The people who are using sedition are also claiming it as a constitutional moment, right? Whether we need to say a little bit more about what the content of that constitutional consciousness is, and can that constitution transcend this rationalism-pluralism divide that I think has characterized it.
Ms. Nandini Sundar, Professor of Sociology at Delhi School of Economics. Ma'am, could you please give your thoughts?
Well, first, congratulations, Rohit. This is such a wonderful book. A week ago, we got an email which was copied to... So it was copied to, it was written to the editor at Penguin and copied to Neja Jayal and me and Rohit, of course. And I need to sort of read out bits of this. So it's to Princeton University Press, dear members of the editorial board. Subject book published by you in 2018 as per graphic attached. So there's a photo of the cover. When one buys a book published in 2018 entitled Computer Programming, one expects the book to contain information and knowledge on artificial intelligence, data mining, and blockchain, and the like, not about basic Fortran programming. So I am shocked to see a book published in 2018 on practice of the law focusing on Nehruvian period between 1947 to 1964. The word everyday usually means the present day unless you qualify it suitably. If you wanted a historical perspective of the practice of the law in India during that period, you could at least have changed the name to read The 50s Life of Law in the Indian Republic. And he's crossed out the everyday and put in 50s in big red marker. Or better still, you could have gone back in a time machine with the help of Princeton's famous icon and published the same in 1970. The book has value only to historians or research scholars of law and not general public, though you managed to get good reviews from people who wanted their name on the book cover. Okay. So I have three things to say about this letter. The first, that despite the explicit claim to be about the Nehruvian period, in fact, the book is about the everyday life of law in India today. And you only have to read the chapters the sort of wealth of detail, for instance, in the third chapter on butchers, the Hanif Qureshi case, and the case that was brought by 3,000 butchers who were across the country, Qureshis, talking about their need to practice their profession and how the bans on cow slaughter were in fact affecting them not as Muslims but as butchers, to see how contemporary this whole issue is, as well as Nehru's comments in the Constitutional Assembly about how, in fact, not having a ban on unproductive cattle would lead to cattle roaming the countryside, destroying agricultural crops. And in the light of contemporary stories about children being locked out of schools and cattle being locked into schools, which is not perhaps detrimental to children's schooling or to cattle's education, this is a very, very contemporary story. And similarly, one could talk about prohibition, where Khandekar talks about how dry days in Bombay are very dull indeed, and we know that days with prohibition are very dull indeed, regardless of whether it's in the 1950s or 70s or in 2018, as well as the chapter on sex workers. So this is a very contemporary book, and I think there is no need to cross out every day and put in 50s. The second thing that is true is that I have endorsed the book because I wanted my name on the back cover, because I'm very proud to be associated with this book. It's a wonderful book, and I think that's certainly one of the reasons why I wanted to endorse it. Third, the fact that this gentleman felt the need to write to Princeton, to write to Nija and me, shows that the desire of multiple citizens to engage with the law extended not only to the Constitution, and Rohit talks about the thousands of postcards and petitions people sent to the members of the Constituent Assembly, but they also feel the need to engage through their letter writing with people who write on the Constitution, even if it's in the contemporary period. What, of course, I don't agree with is that this book is of relevance only to historians of law. As the previous speakers have said, it's something that should be very widely read and is very accessible and great fun to read. So I hope that Rohit will sort of expand a bit more on what the book is about in the conversation later. But I just wanted to sort of flag a few concerns that I had about the kind of narrative this presents, which, at one level I'm in complete agreement with. So, in fact, sort of most of the thoughts that I had about reading the book sort of really came on to drive, because I kept thinking, well, what am I going to say about this wonderful book that is not just repeating what it's already saying? And one is the argument that he makes that this is neither a celebratory nor a tragic reading of the Constitution. And doing it through this kind of insurgent engagement with the Constitution is one way of actually looking at the Constitution itself. Now, I think that's a bit of a large claim to make, because while it's true that it does reflect people's consciousness about the Constitution, I don't think it tells us enough about what the Constitution itself was as a document. And clearly, I think while Austen has this very celebratory kind of narrative about how the Constitution was inclusive, and a lot of that you refer to how it wasn't, and was very limited both in terms of the kind of composition of the Constituent Assembly. But I think, to claim from retrospective engagement with the Constitution that it tells us something about the making of the Constitution itself is something that requires a bit more thinking about. Again, in terms of constitutional consciousness, I think there are two things that we might, again, drawing on the wonderful work that this book has, provided to us. One is where or what we make of consciousness per se, because whether people came to it from a form of constitutional consciousness or whether they came to it from sheer desperation. And we know with most litigants that there is an element of desperation in litigating in this system at all, right? Because it's not, this whole idea of people somehow engaging with the Constitution, and even if they don't get what they want, actually changing the Constitution in some way, takes away from the sheer slog of actually having to go through the whole process of the legal system. And given the common roots of the word prayer, which is what everyone makes in their petitions, and precariat, where it's precisely your precarious nature that makes you engage with the Constitution, I think, although you talk about the fact that many of these litigants were from disadvantaged groups, I think does not bring out, in a sense, the desperation rather than the constitutional aspiration that might have equally driven them. The third thing I think might be interesting to explore further, again drawing on his work, is what Nivedita was pointing to in the sense of multiple understandings of the Constitution outside the courts. So while Rohit's book is focused on the way that people express their constitutional consciousness through legal cases, in fact, there's a huge swath of constitutional performance that actually takes place in a variety of different spheres. For instance, people putting up statues of Ambedkar. Ambedkar's, the whole kind of Ambedkarite engagement with, which again Rohit does refer to, the sort of whole engagement with Baba Saheb is, in a sense, a huge arena of constitutional consciousness, which has nothing to do with the courts, will never have anything to do with the courts, would in fact be ruined if they knew what actually Ambedkar was doing in the Constitutional Assembly. So that's something that might be, and again, Pathalgadi, of course, is another arena, or in all the cases where people are asserting their customary forest rights or their tenure rights, etc. The fourth issue that I think might be important to look at is the limit that the Constitution imposes. And while you talk about it as a limit that, in fact, structures their future engagement with the Constitution, it would be worthwhile to look at how the Constitution might, in fact, have been very different. Because even at that time, there were multiple imaginations that people were bringing to the consciousness. If you look at the way that Gandhi was hugely present despite being absent through the assembly. He's constantly referred to both in the prohibition debate, in a variety of other debates. It's almost as if there was, an absent Gandhi and a present Gandhi in the Constitution. The different constitutions that were provided by the socialists, by the Hindu Mahasabha, the Aund experiment. So there's a whole lot, and of course, all those petitions that people wanted, including the Varnashram Sangha, who said this is not a Hindu constitution, and we were hoping that once we got independence, they were in fact shocked at the idea that temple entry was being allowed, or that religious endowments would now be controlled by the state. So in fact, when you look at the whole Sabarimala issue, again, it's something that is very, what this book shows us is that many of these debates are sort of perennial features, not just of the post-constitutional moment, but also of the period of making the Constitution. And finally, a question that, again, is not something that historians can really address. And I'm not sure how anyone would really address this, but the question that is constantly asked of statistical spread when it comes to analyzing how the courts have responded on whether in terms of taking in ordinary litigants, or whether in terms of addressing market regulations, or whether in terms of minority litigants, or a whole range of questions. Because unless we really have a sense of all the different kinds of cases that the court that came to the court and that the court took up, it's really hard to make an argument with respect to the Supreme Court. And this is a sort of problem that comes up again and again. And so while I completely, I'm persuaded by your argument in the book that these were minority litigants or people from disadvantaged backgrounds who were pushing the law, there is also the other Austinian narrative of, property law, the big Kesavananda Bharati. And when you think of somebody like Kesavananda Bharati, who actually had nothing to do with the case that was fought in his name, the idea that you have citizen litigants pushing the law perhaps doesn't really reflect the full panoply of lawyers and judges themselves. So perhaps this book erred too much in a cheerful direction. But I'm very glad that it did, and I'm glad once again that my name is on the back cover.
I would like to request Gautam Bhatia of the Supreme Court of India to share his thoughts. Yeah, of course you can.
Thanks. I think one of the perils of going last in a panel like this is that all the points you very smugly came up with, you just watch and borrow as one by one. I'll try and be a little nonetheless. I first of all, what strikes me about this book is how timely it is, and I mean it in the sense that, as Lenin said, there are decades when nothing happens, and then there are weeks in which decades happen. And in the last successive weeks now, it seems as if every week a decade is happening in terms of constitutionalism in India, and often it leaves you wondering that is the constitution you are reading the same as those who are tasked with interpreting it finally, that the same constitution they are reading. And in that context, it's always good to go back to the basics, and Rohit's book really, helps us in that way to just take a step back from the daily engagement and the daily fights that are going on, and just lose ourselves for a while in an account of how the Constitution was understood, interpreted by a whole host of actors in the early days after the founding. So in that sense, it was a delightful read. I think the main point I want to make is that we all come to a book with a certain set of ideological and political assumptions, and a lot of how we receive a book depends on what we're looking for from it. And in my sense, as a reader of this book, where I come from is from a position where I think that the Indian constitutional project, as it stands today, is a project that, despite all its flaws, is one that's worth defending. And when I say Indian constitutional project, of course, we can disagree and debate over the precise contours of that project. But broadly, I adopt a definition that Kanabhiran gave in his book of essays. It's a constitution that seeks to achieve social justice within a broad liberal democratic framework. And that, of course, what that means is, of course, further open to debate. But I think that is the core of what the constitution is. And I think that is something that I personally think is worth defending. And whenever you think about that, you immediately think of two strong objections to the project. One objection comes from the political right, and this objection is a familiar one. It's that the Constitution is an alien imposition. It doesn't reflect values that are authentically Indian. And as Rohit points out in a memorable line from the Constituent Assembly, that you wanted the music of the Veena, you got an English band. So you had this argument right from before the days of the founding that the constitutional project that admittedly borrows heavily from constitutional models that came into being in the US and other Western countries was fundamentally unsuitable to India, antithetical to the Indian soil, and therefore is legitimate. And the argument is that today gave us the chance to like come together in a public, and we will draft a constitution that will be fundamentally different from the one that we have. It will focus on duties more than rights. It will focus more on the family as opposed to the individual. You have those arguments that circulate in daily discourse. So that's one objection to our constitutional project. The second objection comes from, broadly called the political left, and that is that the Congress party that dominated the Constituent Assembly was ultimately a party that suppressed, during the course of the freedom struggle, independent agricultural movements, trade union movements, and ultimately ensured that it was basically fighting a war of position, just replacing one set of dominating agents, the British, with an indigenous set of dominating agents. And so again, the argument is that it's not really democratic in a genuine sense. It is again an imposition of the elite who just sought to replace the British with their own set of instruments. And that argument doesn't have too much political strength at the moment, but I think that there's a lot of truth to it, and if you're being honest when you engage with the Constitution in terms of legitimacy, you have to take it seriously. Right? So both these arguments are arguments that are powerful, one politically and intellectually, and the other intellectually at the moment, but you can't avoid them if you genuinely want to defend the constitutional project. And there are a set of facts that both these arguments draw upon. One is that the Indian Constitution was not framed, the assembly was not there by popular vote, by universal adult franchise. It was on the basis of the limited voting franchise the British gave. The Constitution was not put up to popular referendum like in South Africa. So neither were the people who framed it popularly elected, nor was it ratified in a popular election, a popular referendum. It borrowed significantly from the 1935 Government of India Act, and was written in English, which again was a language of compromise and so on. So these are facts you can't get away from. And so, at least for me, whenever you think about the constitutional project and its legitimacy, there's always a haunting and lingering sense that there are problems there, and what do you do? And if you're being honest, these problems are going to keep haunting you. And I think for me, the value of the book is that it, in a new and original way, it helps you understand this conundrum of legitimacy. And the argument as I see it is that whatever the circumstances of the framing moment, the founding moment, whatever the antecedents of those who founded and framed the Constitution, what happened was that when the Constitution came into force, it led to a fundamental rebalancing of power. So what it did was that to those constituencies and to those people who were under the British regime, who were excluded, who did not have political power, but also who did not gain political power from the transfer of political power to Indians, to them it opened up a new avenue where all the disadvantages, social, economic and cultural, that they used to suffer from, and which translated into political disadvantages in the independent Indian regime, were for a moment and in one forum, the courts, rendered irrelevant. So in the courts, these people who did not benefit in terms of representation and political power from independence could articulate their claims and expect a fair hearing. And that, to me, is a fundamental reason why you can have an argument in favor of the constitutional legitimacy, despite whatever shortcomings might have been there in the manner in which it was framed. Because if it enables a set of people to access the levers of the halls of power, which enables them to articulate fundamental claims and fundamental interests with a sense that they will be at least given a hearing and some kind of justice shall be done, whether or not they agree with it, that is a matter of great value and something that should be treasured and prized. And then that really comes through in the 4 chapters, where you have a Parsi civil servant and the context of prohibition in Bombay. You have a merchant trapped in the Essential Commodities Act, a signature project of the early Nehruvian state. You have 300 butchers who come together and who are basically facing this overwhelming sentiment in favor of banning cow slaughter. In fact, so powerful was the sentiment that in the Constituent Assembly, you have Muslim members saying, look, if you want to ban cattle slaughter for religious reasons, then be honest about it. Like we get used to it. But don't do this duplicitous thing where you Article 48 Directive Principles, you say that it's for preserving cattle breed, but actually you're being religious. Don't do that. Just be honest, be upfront, straight, and ban it, which they didn't do, obviously. Given that strong sentiment, you have again the court being a forum where the butchers approach them and claim livelihood arguments, and of course you have the sex workers who challenge the suppression of the Moral Trafficking Act. So each of these constituencies of people are those who, in various ways, find that their crucial interests are not being represented or even being given a hearing in the political domain, and so for whom the political arena, in a sense, doesn't offer recourse, and they find the forum where they can be heard, and that is something that is in itself of value. So for me, that was the core importance of the arguments the book makes. And having said that, I'll now move on to a couple of concerns I had, and maybe we can discuss them. And the first is something that Nandini said, that ultimately I do wonder how much of it was the people and how much of it was imaginative, creative, clever lawyers. In my experience, it happens too often that after the case is filed, the client disappears from the picture, and that's more often the case in constitutional cases, where it's actually all about the lawyers, developing the arguments and of course nominally acting on instructions, but actually the arguments come from counsel. And so I'm wondering how or to what extent can you say that the people, in the sense that Behram Pesikaka, the Muslim butchers, the sex workers, Ushnabai, and the traders, to what extent they saw the constitution as something that was for them, or to what extent were they who actually needed a remedy, approached a logical forum, a lawyer, and the lawyer decided to frame this argument in this very creative, transformative way. And you do, I think, address it to an extent, because often in the book you talk about how the court wasn't the only forum where the claims were made. They were made outside the court before commissioners and so on. And so yes, there is to an extent the question is answered. I just wonder if the answer is enough, because ultimately the book is focused on judgments. Right? It's focused on the arguments made in court and how the court responds to them. And so I'm just wondering if it's possible to make the case that it was still a people's constitution and not a constitution that allowed lawyers to make certain kinds of arguments. And I also wonder if maybe that isn't your burden. Maybe it's enough for you to show that as long as the constitution was a site where these arguments could be made and could be given a hearing, then that's actually enough to make it a people's constitution. The people themselves don't have to make the arguments. It's as long as the arguments can be made, that's enough for it to still be a constitution of the people. So I just wonder what you say about that. The second concern I had is that you argue that that all these cases, in fact, formally ended in defeat. So prohibition was upheld, the suppression of the Moral Trafficking Act was upheld, the Sexual Commodities Act was upheld, and the Cattle Slaughter Act was upheld. And then you say that actually, so there might have been a formal defeat in court, but nonetheless, in the ways that this opened up new boundaries, new possibilities, new kinds of arguments to be articulated of a very progressive character, which were engaged with seriously, as long as it forced the state to come to court and defend itself in the same vocabulary, as long as it actually caused a significant break upon the state's onward charge. So as long as, for example, fascinatingly, you say that the exemption that was given in the prohibition case to medicinal alcohol actually caused the unraveling of the whole regime eventually. So you say effectively that don't look at the defeat just as a defeat in court, but look at its broader context, and it paints a much more positive picture. And I just wonder if that is, I see the sense of that, but I just wonder if, again, it gives us a sense of false optimism or happiness about our past, because when I think of it, what I find is that prohibition not only as a regime continued in different states, but actually you now have the Supreme Court itself going ahead and on a PIL, banning alcohol within certain distances from highways, and then walking back because the fine justice can't implement it. You have a trafficking bill that replicates many of the very, very problematic aspects of the SITA that has been passed in Lok Sabha last week. you have a progression of capital order laws that become stricter and stricter, and ultimately you have in 2005 the Supreme Court giving in completely and upholding a complete ban that goes backwards from Qureshi, and the bureaucratic regime that you talk about in your Essential Commodities Act chapter is replicated in so many ways in anti-terror laws, right? And so I wonder if we actually want anything. It seems to me that those, by we I mean people who believe in that broad civil rights perspective, at least in terms of the laws and where the law has gone, it seems to me that it's actually been, and it might sound pessimistic, but just a string of defeats. There's been no real victory as such, and so I wonder what to think about that. Last, and this is not an objection or a concern, but it always fascinates me and fascinates me more reading the book, is how much more progressive the High Court seem to be each time in the Supreme Court. Each of these cases involve a situation where a High Court gives you a much more radical, and I use the word with caution after Pratap's warning, a much more progressive, much more pro-civil rights judgment, which is then watered down by the Supreme Court. It seems to me that that's a trend that has been consistent across our history from the 50s and 60s, which I now know about thanks to the book. 70s, the emergency. 80s, a case like Sarita versus Venkat Surya. More recently, the bail judgments in Kabir Kala Manch. It's APCLC judgment in encounter killings. It seems to me each time, 377, of course, yeah. And the High Court judgment still remains in many ways, in pushing the law forward much more radical than the Supreme Court judgment. And I just really wonder why we still always somehow think that the Supreme Court should be the first and the final, forum where anything happens, we run up straight there and think we'll get justice, and then we are shocked when we don't. I just wonder that a book like this, could encourage us to try the High Courts a little more. And this is not a broad defense of the High Courts, and there are issues there as well. You have judges who will give you the Kanhaiya Kumar bail judgment about gangrene and cancer, right? So you'll have that as well. But yeah, I think it's definitely, to me at least, once again, it fortifies a broad skepticism about the Supreme Court, in a sense that before we go up there, we should try other judicial forums if the battle is going to be fought in the courts. So that, thanks a lot for this book. I learned so much. It was a wonderful read.
Finally, may I request the author of the book, Rohit, to talk about his book.
Hi. I'm actually not going to talk about my book in detail for two reasons. One, I'd encourage you to read it. And secondly, Gautam has done a wonderful summary of the book on his blog, the Indian Constitutional Law and Philosophy blog, which I'd encourage people to read. So what I'm going to do with a little bit of time here is sort of talk a little bit about the conditions that made this book happen, both sort of personal conditions, but also structural conditions, and maybe try and attempt some of the questions that were raised by my panelists. And I'm hoping we could end this with actually a broader conversation between the panel and the audience about some of the questions this raises. So firstly, this book is a product of immense generosity of other people, generosity of time, resources, and ideas. I'm particularly grateful to my publishers, Penguin, Princeton, Sudhanshu, and Shruti, for organizing this. And I'm thankful to friends and family, particularly my parents, Ranjan Anuradha and Surabhi Ranganathan, for their support that made this book and this event possible. I'm really delighted, and I can't explain how excited I was when all of you said yes to being on the panel. It's quite a dream team, partly because reading all your work really influenced my writing of this book. And I'm going to briefly mention sort of the ideas that helped me think through this. So Pratap, I think almost a decade ago, wrote a piece talking about how while there are several studies of the Constitution, it remains very ill-served by historical imagination. We don't really have a sense of what people thought they were doing when it was enacted. We don't have a sense of how these concepts and principles were adopted in daily life. Nivedita had sort of two bodies of writing. One initially, which was very coming from the sort of feminist thinking about the law, quite skeptical of legal forms and legal processes. But post 377 judgment, I remember reading your post, which was a sort of moment where you're almost blinded by the possibilities that law offers. And I think that tension sort of comes through the book as well. Nandini, I really enjoyed because one of the things I struggled with was this whole body of writing in political science, which argued that in India, we don't really have what is called civil society organizations. Civil society or traditional political organizing concepts are always exclusionary, and all that the sort of poor can exist in and negotiate through are through kinds of illegality and corruption. And also Nandini's more recent work, which focused on the kind of use of the constitution and law in areas that were almost written out of the constitution and law, were inspiring and thinking through. I think I once said when I grow up I want to be Gautam Bhatia, but I think Gautam's sort of both severe critique of the way of our constitution, but also kind of real love for it shines through in his writing and has been influential in reading. So, as I said, most of the research we do is biographical and is really about the times we live in. And as I started this project, there were sort of two trends that were coming through in thinking about the law in India. One, as Nivedita mentioned, was an increase in sort of social movements ranging from, the right to food or the right to education groups, right to information, the 377 decriminalization movement, which saw the law as, saw transforming the law, saw engaging with the courts as an ultimate end to social transformation and inclusion. But at the same time, a range of legal scholars, including Anuj Bhavania, Usha Ramanathan, and Nivedita Menon, were arguing for caution and suggesting that what the turn to the law and particularly turn to the courts was doing was actually increasing the power of judges and lawyers and taking away agency from many of the litigants. So I wanted to write a history of, I wanted to think about the constitutional law in a way in which, while the courts remained the central archive, lawyers and judges were not the central actors, and try to see if there are ways in thinking about the law where the authorship of the law is more diverse. For this, the 1950s seemed to be an ideal time, partly because what I got from both my sources and from people thinking and remembering the event is a sense of uncertainty, a sense of newness, and a sense of optimism. So Mahesh Mahajan, who's a judge in the Supreme Court, says, we didn't really know what the Constitution was. I had to borrow all these books in American constitutional law to understand how to interpret this. We hadn't had any experience of it. You also had a situation where when both parties came to court, nobody had a clear sense of who was going to win or how this case would play out. So the Supreme Court and the High Courts were actually creating sort of new ways of interpreting texts, coming to sort of new kinds of answers. This kind of popular sense of newness, imagination also existed with both the government and with the sort of public at large. So with the government, and we see this repeatedly in the writings of figures like Nehru and others, is a sense that we have finally acquired sovereignty. This is our government. Of course, we are committed to a constitution. And if the constitution comes in our way, we will amend it, but we will still function according to what the new amended constitution is. So the sense was that the government's legitimacy really comes from the fact that it represents popular will. And we again see Nehru saying at several points of time that this will has to be exercised through sort of elections, famously telling a bunch of student protesters saying, now that we have become independent, you can't do this kind of politics. What you have to do is, you vote in elections and you sort of perform your duties as a citizen. There's also a kind of clear imagination of what this new Indian citizen is going to be. Ideally, someone who doesn't drink, lives a somewhat austere life, works for national progress, is not profligate in terms of alcohol, is ideally vegetarian, and in some ways sort of inclusive, secular, obeys the law. And we see a lot of this through the kind of films that are made by the films division on how to be an ideal citizen. As Pratap mentioned, it's very clear that this new imagined citizen didn't actually look like almost anybody in India. So whenever you had an attempt to sort of put in this imaginary through law, you face dissidence in a variety of ways. How do you sort of deal with a new person's, the new state encroaching in your domain when you're suddenly arrested for the case about prohibition opens with a gentleman being arrested for his car hitting someone else. It's clear he's not driving negligently, but what he's charged with is consuming alcohol, and the only proof they have is the constable sniffs his mouth and says he has consumed alcohol. So are your rights dependent on a constable's nose, right? Or can a magistrate eject a woman from a neighborhood because he believes her to be following prostitution? How do you deal with this new bureaucrat sort of showing up in your domain? They didn't didn't have a lot to fall back on. So previously, you could do a range of things. You could, of course, bribe your way through it, which I'm sure many people did. It's not visible in the archive. You could, as you were encouraged to do, work through democratic systems. So make this an election issue. And we see several sort of contentious topics being resolved. The land reforms is the best example of something where political groups were able to mobilize and water down. However, what happens if you belong to a community that is not a popular community, a community that can't win elections? And while the sort of four sets of figures who appear in the case, Parsis, Marwari traders, prostitutes, and Muslim butchers, have different kinds of access to sort of social capital. Some are wealthy, some are not, some are educated, some are not. What's common to all of them is that they kind of are unpopular figures in independent India. So the Parsis are sort of effete anglicized and were pro-British, and their loyalty is somewhat suspect. The Muslim butcher is like the kind of the most villainous figure possible. The courtesan prostitute is someone who sort of weakens national character. And the Marwari trader is vilified in government propaganda as the wrong kind of capitalist, the one who is uneconomic, who hoards, who doesn't really create economic product, unlike the great nationalist industrialists. So it's very hard for them to sort of appear in the public, win elections openly, and sort of campaign on their issues. So what, as Gautam pointed out, the law offers is a way for them to sort of hide through constitutional law. While they are asserting interests because they are differentiated citizens, their interests are done through a kind of unitary image of constitutional law. So, for example, the cases involving the prostitutes, they go to court and they make two claims. One is that they have a right to practice their profession because the Constitution protects the right to practice profession. The other is that they can't be ejected from a neighborhood by a magistrate without being given a right of the hearing. The first claim doesn't go very far because the judges say, yes, it's a profession, but it can have reasonable limits on it. But the second is something that judges feel very strongly about, particularly because the magistrate in most states at this point of time is still an executive magistrate, not a judicial magistrate. So there are a variety of ways in which the powers of magistrate are curbed because of the litigation brought about by these women. The question that Nandini and Gautam both pose is an important one. To what extent is this really a story about ordinary people and their victories? Empirically, in some ways, it's not. These are cases that largely come from urban areas, not necessarily big towns. There are small towns and kasbas as well. But almost none of these cases come from rural areas. We don't see peasants in court in large numbers. And while many of these groups don't belong to sort of Savarna castes, it's clear that there aren't a large number of Dalits or tribals who are appearing in these cases. But I don't think that is, and I think partly, Gautam has done my work of establishing this for me. I don't think that by itself, as a kind of empirical description, limits our ability to think of this as a constitution that reaches down. What it shows is that the state remains open. And groups that have a certain degree of capital, and doesn't have to be financial capital, can often be informational capital, are able to use the constitution to protect its interests for a certain period of time. And I was very puzzled at one point to discover figures like beggars, prostitutes, butchers, in the court in large numbers. And as Pratap mentioned, some of these trends go back a long way. Even in the 19th century courtroom, you see many of these figures. And it suddenly came to me that if you're a community that is heavily regulated and you face the brunt of the law, you're much likely to know the law better than someone who belongs to an elite family, has not been exposed to the law, or wouldn't really know a lawyer or a policeman. So it's interesting that the very day the Suppression of Immoral Trafficking Act goes into force, the next day in 3 different cities, 3 women who identify as prostitutes go to court and file a writ petition challenging it. So there's clearly they know the law is coming, they know what to do, they know a lawyer who they can contact. We have a kind of belief when we think about constitutions, and it's very hard to sort of get rid of it. It's a kind of evangelical belief. The idea is that a constitution is a revealed book. We will read it, and it will transform ourselves and our internal consciousness, and then we'll strive to sort of change things. And that's something that I was very tempted to look for. And what I've tried to do, and I've tried to be cautious to suggest that this isn't necessarily the case, but at some level it doesn't matter, right? So of course some people read the Constitution, are transformed in it and believe in it effectively. Others use it strategically. But what matters is that in the public discourse, this language is out there and the government has to contend with. So for example, again in the case of the prostitution, you have a large number of sort of Indian leaders of the Indian women's movement arguing for sex work to be heavily regulated, suggesting that prostitutes should never get bail, and in some cases suggesting that this constitution should be amended so that prostitutes can't claim rights under it. And they are challenged by the fact that there are these women who appear in courtrooms who speak in a kind of language and reverse the logic of the state, saying that they're productive economic citizens. If their profession is being shut down, then the state must guarantee them welfare through other ways. I'm just going to end by talking about the sort of missing group and a major factor in this, which is the lawyers. There is a reason why I think this happens in India, and the Indian constitution has a particular history compared to other places. India in 1950 had about 70 or 80,000 lawyers. It sounds like a small number, but it's the second largest in the world in any country. And if you start comparing this to other colonial states, so Indonesia has about 25 indigenous lawyers, Kenya has 1. So the South Asian states really have a much larger number of lawyers. So when you are in trouble, you have someone to go to. These aren't human rights lawyers or civil liberties lawyers. These are often like the guy who sits under the tree who tells you, here's a new way to do it. And in some ways, the lawyers sort of ease the motion. But it's clear that the legal arguments sustain themselves beyond the cases themselves. I just want to point out one story, and I'll maybe close and turn back to the panel. The story I begin with is the story of this vegetable seller in Kairana in Uttar Pradesh who doesn't get a license to sell vegetables. So he goes to the court, in fact, jumps the High Court, goes straight to the Supreme Court. And while the case is going on, the municipality of Kairana writes very angrily to the court saying that this guy has hired a drummer who's going around town beating the drums, saying that the people have filed a case against the city and the people have won. The case hasn't yet been decided. The case is still going on. Somehow Muhammad Yassin becomes the people. But there are ways in which I think, and I think in some ways it's hard to do this archivally. It's perhaps easier to do this in the present if we are sort of doing ethnographies. There are ways in which the constitution exists outside of the courts, and we see fragments of them using language. The other example is the sex workers, even after losing the Supreme Court case, basically ghirao MPs, challenge policemen, saying that Article 19 gives us the right to practice our profession. You can't take it away from us. And I think one thing that we need to do is to be more better at listening to these moments of constitutional assertion outside of the framework of the courtroom. So with that, I'll close and maybe turn to the panel and for more questions. Thank you. Take questions from the audience, and then I don't want to be the only person to answer, so I'm sure there are things that everyone else has.
So we're open for questions, and whoever wants to ask any question, please raise your hands. Yeah. Sudhanshu, can we have a mic? The one in white, yeah.
Thank you. Hi, thank you so much for a productive discussion. Rohit, I have 2 questions for you. One is, how did you arrive in your research while writing the book? And this is based on your PhD thesis, if I'm not wrong. Yeah. So how did you arrive at these particular discourses on sex work and policing, prohibition, or the case of butchers? And my second question is that while you were doing research and writing this book, how much do you think in these cases was the voice of people like sex workers and not the voice of the movements or the groups they originate from? From the process, from the time they filed the cases to when it was being discussed in the courts. So how much was the voice of the movement itself than the sex workers? And I'm just taking sex workers as an example because I've read that chapter, but yeah, thank you.
Thank you. They're both really great questions. So I didn't begin looking at these 4 areas. I was actually looking at laws which were being enacted by the new government which sought to transform some aspect of everyday life. So in some ways, all these cases are about food, drink, shelter, and sex. And I looked at a whole range of others on housing and things that didn't find me in education, which didn't make the book eventually. 2 things surprised me. One was when I started looking at this, I didn't expect that the cases under each type would be brought largely by members of the same community. So almost everyone arrested under the Essential Commodities Act is Marwari. Most people challenging prohibition are the prominent names are Parsi. Almost all the cases of people arrested under the Child Protection Act are Muslim, and even in the prostitution cases, it's a very broad category which describes a whole range of people doing different kinds of activities. But the name suggests that they belong to some kind of survived tradition. The names of mostly Muslim women. So So there's a kind of relationship between community and regulation that seems to come through. And I think this helps me maybe answer your second question. So I again don't know how much of this was, except for one case of a Parsi journalist who gave a lot of interviews, I don't know to what extent it was their own personal transformation. But I think we tend to sort of divide individual rights and rights of community as two separate things. When the kind of regulatory effect came out, it affected both individual rights but also community practices. And I think that has to do with the way in which our society's economy is organized around caste lines. The reason why these individuals could move was often because there were other members in their group who either provided them information, or in the case of the sex workers, there were police reports that people are collecting money in red light districts to mount a legal challenge. So while it looked like an individual case, it's clear that they were appearing on behalf of a much larger group. And this was a kind of community strategy. The Netherlands state often tend to dismiss this by saying these are vested interests, right? There's national interest versus vested interests. And I think what the book tries to do is to try to make a case for thinking about these vested interests more sympathetically. And not just take the national interest as something that is normative, assured, and correct, and the vested interest is always something that is bad.
So Rohit, do you really feel that Constitution has really changed the life of people?
Yes. I can either give you a very short answer or a very long answer. But I can tell you this, right? So
Okay.
we know what happens before there's a constitution. It's not as if people don't make assertions for rights. But the ways in which you can make assertions in colonial India are quite limited, right? So the two kinds of things you can say is either the colonial government protects property broadly, so you can say it's my right to property, or you can claim it's some kind of custom or religious right. But beyond that, there's very little that you can do. You do know that the colonial government continuously writes, there's no document that you can peg procedural fairness on, and there's no sort of claim to representation the colonial government makes. So there is a distinct shift in how claims are done and how people sort of resist the state before and after independence. The second is something which Upendra Bakshi has written, which is the constitution is many things. One is a text, the second is constitutional practice, which our lawyers and judges do, and the third is really this idea of constitutions as insurgent imaginations, where groups that are often outside the constitution and are not seen as part of the constitution write themselves into it. I think sort of the work that Jignesh Bhanu was doing and recently referred to is one of those strategies. One can see sort of similar actions being done in other places where the one thing that allows you to protest legitimately is the constitution. So even if you're a group that doesn't believe in the constitution, you might choose to use the constitution as a way to sort of resist it. And I think it does have, despite what's been happening in the last few weeks, still some degree of traction.
I think there's a fantastic article by Robert Cover where he talks about how the Constitution becomes a site where competing narratives clash. And he gives this very interesting example from American history. He talks about how at the time that the Dred Scott case was being decided and American slavery was very much an institution. This was before the Civil War. There was a group of abolitionists who, and this was before the Civil War, so still slavery, and no American constitutional provision explicitly outlawed slavery like it did after the Civil War. And there was a group of abolitionists who basically consciously framed their anti-slavery arguments in constitutional terms, where they said that a constitution that specifies that, a declaration of independence that specifies that everyone's created equal, a constitution framed in universal terms cannot contemplate slavery. And they were dismissed as extreme, they were dismissed as fanatics. The constitution itself actually provided that for apportionment of votes, a black person would count as 3/5 of a white person, specifically in the constitutional text. So it was like, what are you saying? This makes no sense. But they made the argument, and ultimately in the long run, it was written into the constitution. Another interesting example from again American history is that you had all these labor lawyers who had this tradition which they called labor republicanism, small r republicanism, where they said that the American 13th Amendment that outlaws involuntary outlaws servitude, that actually contains an affirmative right to a fair wage, because not paying a fair wage effectively in a market economy means that the capitalist is exploiting market conditions to place the workers in servitude, right? And again, they were dismissed as completely wacky, and they tried an argument, and the Supreme Court didn't accept it because American Supreme Court know what it's like. But again, the idea is that the Constitution provides a site or a terrain where groups can understand themselves and frame claims that may not in the long run become part of what we understand as law, but nonetheless plays a very important role in those groups identifying themselves as groups and coalescing around the shared aim or shared goal, which itself is important in this one.
Hi, I just wanted to ask some more about the cheerfulness of the book, mostly because I want to be as cheerful about the Constitution as the book is. And what either pushed you or should continue to push us to view the turn to courts as something to be cheerful about versus a more pessimistic reading that, well, the Constitution gave too much power to the bureaucracy, assumed that the state would do what was good for its citizens, and therefore really the only alternative that you have, instead of a more participative measure, either at the legislative or executive end, is to subject yourself to what is ultimately still an expensive, uncertain process, where the state has been screwed over less than litigants have, and maybe whether the answer to this either lies in comparative work you've done, where you think our Constitution still has done a better job of allowing that kind of uncertain contestation, either that other constitutions did in a similar time period, or simply that, well, we could have done worse and we didn't.
I'm hoping some of the others will also answer this question. It's also a really good feeling to have one of your former students here in Delhi and ask you questions about your book, which I was writing all the time I was teaching you. I began the book on a really optimistic note. I started my research. I studied in law school, kind of assumed that turning to the law is the most obvious thing possible. It took me 3.5 months to even get access to the courtroom, despite being a registered lawyer and knowing the Chief Justice. Working in the court made me aware of how difficult access to the court is, and how actually it was really remarkable that the fact that these people arrived to the court in the first place. So I think to sort of also turn to Nandini's comment about aspiration versus desperation, the fact that these cases exist and these people are able to get to court is a remarkable feature. It isn't necessarily one about the Constitution, it might be something about Indian polity, Indian society, or about their own ability to sort of negotiate the barriers. But they come in and they force themselves onto the Constitution manually. There is some statistical information which shows a breakup of at least Supreme Court litigants. A bulk of them are, the two big proportions of people are government servants, who are the most frequent litigants, and the second are business people. But there are a variety of other categories that are more surprising. So students, refugees, are other groups. And what is surprising is across the board, in about 40 to 45% of the cases, the government loses, which is a fairly large number for a constitutional court. So, I mean, Pratap has tried to sort of theorize this in one of his pieces called The Promise of Uncertainty, where he suggests that what allows the Constitution to function is the fact that nobody wins 100%. So everybody feels they have some stake to continue in participating. I don't think it's the sole medium, and I think there are multiple ways to do so. And I think the ability to last the system depends on your ability, on your level of desperation, or on the kind of resources that you have. But I'm hoping some of the others will.
This kind of also picks up from what you said, Rohit, about my suspicion of the law and then my being blinded by the beauty of the 377 judgment. My suspicion of the law was always also about saying that one has to engage with the law to remove disabling provisions. So Section 377 is a disabling provision. It has to go. You have to engage with the law to say repeal Section 377. So that was, there's a distinction between that and enabling laws. And my suspicion has been towards enabling laws, and I still have that suspicion. Removal of disabling laws is a basic minimum, and we would have to do that. But to link up to the cheerfulness and so on, and also the very first question about movements, I found that very an important intervention in this creative lawyering versus clients things. I also did think of this, but that would have taken away another point of view. I did think of this because we've all been involved in different kinds of interventions of late on copyright. Our creative lawyer sitting right here, Swati, and we know. I mean, we know how much work lawyers put in to shape judgments. Justice Chandrachud acknowledges this publicly, not many, and you can see Justice Chandrachud's judgments reflect a lot of work, academic and work by young legal, the whole team. Yes, there's creative lawyering, and then there are clients, but I would have raised the point, but then I found this sentence actually, which stymied me, so then I decided not to raise it. When he says the lawyers who appear in this book are largely ordinary lawyers, and he also did mention that the chaps who sit under trees kind of thing. But to look at it from the point of movements makes it very interesting, because then it's not it's not this one sex worker, but a sex workers movement which is backing her. Or I thought that was a very, very important point. So that's where the cheerfulness, I think, comes from. And I also did see this as an attempt to craft an understanding of the Constitution. I don't think any of us is under the impression that the Constitution is an enabling document. It's a document which establishes a class order. It establishes a gender order. Rohit talks about the way the market replaced property as the basis for the new rights order. So we're not naive about that. I think what Rohit does in the book resonates with what I currently see as the potential to use certain aspects of institutions in ways they might not have been intended for. So if Pathargari uses PESA, or if RTI uses Article 19, they're going to court, they're getting a law, but what they're doing is movement. What they're doing is struggles on the ground. They're risking their lives, for example, the RTI activists. So I think that's where the cheerfulness for me would come in. I don't see this book, and you would know better than me if you actually journeyed with Rohit as a student. It's a way of producing a narrative about the Constitution that can be enabling. I think that's what this book is doing.
Can I just add what else can one be but cheerful about the Constitution, given that people are trying to subvert it at the rate that they're doing now? And the fact that even people who oppose the reservation, the 10% quota, are hoping against hope that the Supreme Court will strike it down shows that, in a sense, that is the only optimism that they can feel nowadays.
One sentence in this, I think I think there are two ways of looking at it, which is, one is you measure the kind of success by a range of substantive outcomes, right? Social justice, liberty, redistribution. There you'll get a very mixed, probably pessimistic picture. In fact, I think Rohit's argument actually, despite all the things that judges do, it's actually how pro-state the Supreme Court has been in philosophy, not in terms of actual litigation. I mean, even when it makes radical pronouncements, the remedies in the state are like, in all your cases it shows up, right? I think the real achievement, I think that's the texture, is really as a kind of mode of being in form of action, right? And you can have mixed views about this. I mean, the radicals that Gautam talked about, who are skeptical of the Constitution, will say is actually, there's that argument that judicialization depoliticizes. It actually has detrimental effects on social movements, right? But as a form of action and being, where as a society we say to ourselves, we have lots of disagreements, we do all kinds of crazy stuff, but this is how we resolve it. Sometimes at the mercy of mundane administrative lawyers who find arcane ways out of this. Sometimes at the mercy of judges. It's law as a mode of action and resolving disputes. That, I think, is the optimistic story about Constitution. It's not so much sort of what objectives it achieves. It's that as the instrument itself by which we agree to do it.
Uh, yeah. Thank you, Rohit, for this wonderful book, and thank you all the panelists. I think although your book ends somewhere around, it's a historical work that looks at the era till 1964, and although all the cases that you have looked, they end in a defeat, but if we still have to understand the constitution as a people's constitution, I think that there is a role of judiciary that has upheld the ethos and the spirit of constitution, because once we move from the decade of 60s and enter the decade of 70s, we see the rule of locus standi uh, 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 being moved, and we have the PILs being introduced, and the judiciary is, I have quoted Pathumna in my own dissertation, where the judiciary says that the document is for non-violent social revolution, and we are ought to bound by it. So in a way, this is people's constitution. I would like your comment that this is people's constitution because the active role of judiciary that has understood the ethos of it and time and again played their part in all the cases where they have even started a litigation when they received a letter and said that this is enough for us to take a suo moto action. So how do you view the role of judiciary as a silent player in people's constitution?
Jay, thank you so much for your question. And I think it helps me answer the question about periodization. So the story we've often been told is the Supreme Court of India in the 50s and 60s was a conservative body, largely, and I'm caricaturing broadly, protecting the rights of property owners, and there's the emergency where the Supreme Court fails to uphold the rights of its subjects. It's deeply embarrassed, and it sort of performs a kind of reformative role by, in the 80s and 90s, sort of allowing for PR, diluting local standi, allowing for a broader range of claims. Anuj, who's sitting here, I think very effectively demolishes that second myth, the second part of it. And I think others like Nivedita and Usha Ramnath have also pointed to is that in the 80s what we see is, I mean, Anuj proposes it very radically, is almost the emergency in another form, where the judges who are pro-emergency sort of take on the language of the people and expand judicial power. And in many of the cases, we see the petitioner being totally displaced, and this becoming a story about judges trying to resolve disputes. I'm hoping to challenge the first part of the story, which is that in the 50s and 60s, the judiciary was deeply conservative, committed to protecting the rights of property holders. We see what we later on describe as PILs, kind of social movement engagement, already happening in the 50s and 60s. It's just that these social movement groups don't look like modern NGOs. What they often are something between professional associations and caste groups, but they're working around questions of law. The other distinction is one about making claims on substantive rights and making claims on procedure. And I think that's something that Anuj and my work comes together on, is that, and I think there's a whole bunch of us who are now turning to thinking about procedure. So the longest story was procedure is arduous, it's painful. Justice Krishna Iyer said procedure must be a handmaid to justice. So legal reform was seen as a way of getting rid of procedure. At least in the early period, at least what the archive shows me, is that very often claims for rights are not successful or are dependent on the judge's personal, impression about the world. But what seems to stick are claims and procedures. So the judge might also agree that prostitutes are people who do not engage, should not be respected, but is queasy about allowing a magistrate to dismiss someone from their neighborhood because today it's a prostitute, tomorrow it might be somebody else. So there is a sort of narrow victory they win on procedural rights, which is, I think, something that one needs to recognize. Whether this is out of some kind of great, the judiciary sort of great thinking about the people, or the inherent conservatism about how procedure must be protected, I'm not entirely sure. But I think it helps us really think through the earlier period, the pre-PI period, in a different way. Rajshri.
We are actually short of time now. So can we make that last question, please?
I'll make it the last question.
Thank you.
So Rohit, I haven't read the book, so my question may be, I'm hoping it's not misplaced, but I'm struck by a thread that runs through the 4 strands that you pick up. Each of them is a pushback on a dominant idea of propriety. And in that sense, each of them is an assertion of a liberty right. Now, one of the celebrated aspects of our constitution is the fact that it balances sort of civil liberties with socio-economic rights. I'm wondering why your book, if it does, since I haven't read, I haven't seen it, but I'm wondering why your book is not equally attentive towards assertions of customary rights of people, socio-economic caste groupings, social movements around those categories?
Thank you. That's actually a great question to end with because it helps me make the point that I forgot to make when I was introducing the book. So one of the things I want to do is to challenge this sort of separate conceptualization of sort of liberal individual rights, communitarian social rights, and economic redistributive rights. So a case that looks like a classic liberty case is around prohibition. You have a Parsi journalist, public-spirited citizen, going to court and saying he has a right to have alcohol in his house. What becomes quite clear is that he's not acting by himself. He's acting because there are a number of Parsis who are litigating prohibition. The Parsis have been deeply involved with the alcohol trade in Bombay, and prohibition has devastated them economically. Right? So what looks like an individual liberty right is actually backed by the interests of a community who are also deeply invested in protecting their property, in this case their businesses. And this is a property that is also shaped, the Parsis have liquor contracts because in the late 19th century, the colonial government gave liquor contracts to certain communities who were seen as better at the profession, had better access to it. So it's Parsis and Bhandaris. So similarly, the Essential Commodities Act is supposed to target everybody who is involved in smuggling or hoarding, but everyone arrested is a kind of Marwari businessman, not a big industrialist, but the kind of guy who has a small business, a kind of like trading things in the shops. And it's clear again that they are not acting independently, they're acting in consort. So I think what looks like a liberty claim is actually a property claim and is also a community claim. And what I'm hoping to do is to sort of break down the kind of liberal notion of these being sort of separate ideas.
I have a response, but it's the last question.
Thank you.
Thank you for being understanding. Okay, on behalf of Penguin Random House, I'd like to thank you all for coming tonight, taking out your time. And I would like to thank the panelists for the discussion and wonderful insight, and of course, Rohit for the same, and for all the hard work that has went into the book. Thanks a lot. We're open for book signing. Also, the books are available, and Rohit will be glad to sign the books for you. Thank you.